23, 2025 special telephonic meeting of the Connecticut State Elections Enforcement Commission is called to order. My name is Steve Penny. I chair the commission, and I'd like to welcome you to today's meeting. This meeting is being conducted virtually in accordance with the Freedom of Information Act, which authorizes public agencies to conduct meetings in this format. The meeting is being recorded for on-demand viewing and will be available for at least 45 days. Because of the virtual format of this meeting, there are some specific rules and procedures that I need to cover before we begin. First, I ask all participants to mute your device when you are not speaking. Second, all speakers must make a good faith effort to state the speaker's name and title at the outset of each occasion that such speaker participates in the meeting. Third, all votes must be taken by roll call vote unless the vote is unanimous. With that said, I'm going to ask the other commissioners and the executive director to identify themselves at this time, please.
Commissioner Michael Agello.
Commissioner Shannon Berquist.
Greg Pietzu.
Commissioner Sonia Morello-Sari.
Ryan Burns, Executive Director and General Counsel.
All right, the first item on today's agenda calls for us to go into executive session. Is there a motion to do so?
So moved, Pietzu.
Second, Berquist.
And seconded. Any discussion? None appearing. Those in favor of the motion will raise their hands and or say aye.
Aye.
Any opposed? Any abstentions? None appearing. The motion carries with 5 voting in favor, none opposed, no abstentions. So Renata, please put us in executive.
Mr. Chairman, you may proceed.
Thank you very much. All right, we have concluded our executive session. No decisions were made therein. Do we want to make a record here now, however, of this issue as we discussed it?
Yeah, so you have two applications before you, one of which was addressed. So I think we can make the record at the time you're considering that grant application.
All right, then we'll proceed to deal with the two applications that are pending. First is Friends of Larry Pemberton. Director Minier, please.
Thank you. Good morning. For the record, Salman Munir, Director of Audit and Disclosure. I have two grant applications today from Special House District 139. Number one is Friend of Larry Pemberton, Larry L.I. Pemberton Jr., Special House District 139. Committee have raised total 189 counts and $5,247 in dollars. Committee has total number of qualified in district 135 contributions, and total dollar amount of qualifying contributions are 4,987. Committee has met the threshold and recommended for the grant approval.
All right, is there a motion to approve the grant?
So moved, Pietsu.
Second, Berquist.
It's moved and seconded. Any discussion? None
I
appearing.
take it-
Those in favor of the motion?
Hold.
Yep.
When would be the appropriate time before we?
So I will address the referral after you vote on the grant approval.
Okay, thank you very much. I'm ready to vote.
So ready to vote. Those in favor of the motion to approve the grant will raise their hands and or say aye.
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 Opposed, any abstentions? None appearing, the motion carries with 5 voting in favor, none opposed, no abstentions. Next item on the agenda is Brandon for CT.
I'm sorry, Mr.
Well,
Chairman,
you
if
wanna
I may,
have
there
to
was
discuss-
one other item to consider with regard to the Friends of Larry Pemberton.
Yes. Fine.
Mr. Chairman, it would be my recommendation that the commission refer for investigation certain contributions that were made that may represent straw contributions with regard to the Friends of Larry Pemberton campaign committee.
Right? Is there a motion to refer the matter on the terms that were just described by the executive director?
So moved, Pietsu.
Second, Berquist.
Moved and seconded. Any discussion?
Do we
None
want to
appearing,
have any
those in favor of the
substitute?
motion will raise their hands and or say aye. Aye.
Aye.
Any opposed, any abstentions? None appearing, the motion carries, and the matter, this particular campaign and the particular issues involved will be referred to for consideration by the enforcement unit.
Mr. Chairman,
Yes,
were we going to go into any detail as to the reasons behind that?
we can. I think that would make sense. We voted to make the referral, so do you want to have a discussion about that at this point?
Well, given the election coming up, just for disclosure, I think there was some discussion about possibly just disclosing the basis for it. So, and I'll just summarize, and if staff wants to jump in, they can. But actually, why don't I defer to Attorney Keefe?
Good morning, Commissioners. The grant application review revealed a single credit card was used to make 8 separate in-district $5 contributions that were submitted toward the 113 in-district threshold required to qualify for the grant. These contributions were purportedly made by 8 individuals with 5 different last names residing at 4 different residential addresses and using 2 different emails.
Right, and we have voted to refer this matter in that regard to enforcement. And that was also a recommendation of staff. What would be your comment on why that is appropriate and necessary? Attorney Keefe.
Just because a credit card usually isn't utilized as personal funds and paid by the personal funds of so many people living at so many addresses. And so we need to look further into this and find out what's going on and prevent it from happening in the future.
right? And it has an impact on whether a campaign qualifies for the grant or not, does it not?
It does, yes.
It can, but not in this particular instance as it would have.
Here they raised excess contributions, and so these were able to be set aside, and the grant that you just voted on is not at all based on these contributions.
Commissioner Pietzo, do you think we've covered the subject, or is there anything more that you think we should add?
I think that gives a valid explanation for the basis. Thank you very much, Mr. Chairman.
Thank you. All right, so the next item on the agenda is a grant application by Brandon for CT. Director Manier.
Brendan CT, Brendan Sebag, House District, Special 139. Committee has raised total 188 contributions and $4,515 in dollars. Committee has total number of qualified in-district contributions are 122, and total dollar amount of qualified contributions are 4,385. Committee has met the threshold and recommended for the grant approval.
All right, any questions or comments for Director Manier? None appearing, is there a motion to approve the grant?
So moved, Pietzu.
Second, Berquist.
Moved and seconded. Any discussion? None appearing, those in favor of approving the grant will raise their hands and or say aye.
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 Any opposed, any abstentions? None appearing, the grant is approved with 5 voting in favor, none opposed, no abstentions. Next item on the agenda is public session, file number 2024-101. Attorney Smith.
Good morning, Commissioners. For the record, Attorney William Smith for the state of Connecticut.
Good morning, Commissioners. Attorney Carol Ann Rowe, counsel for William Jenkins in this file. Thank you very much.
Right, so there's a motion to dismiss. Did you want to present your case, Director or Attorney Rowe?
Well, I do believe the motion is self-explanatory, but I would just like to highlight the basis of our motion to dismiss is that essentially the jurisdiction that this commission has over this complaint has timed out and has timed out as of December 21st, which was this past Sunday at midnight. The original complaint was filed October 22nd of 2024. The commission, as you all know, needs to render a final decision before the 1-year mark. That 1-year mark would have been October 22nd of 2025. There are some exceptions that do extend that 1-year mandate. And one of the exceptions are continuances that may be granted. We have 2 continuances that were requested, one by Mr. Jenkins prior to retaining me as his counsel, and one that Attorney Smith and I had agreed upon. As you read through my motion, you'll see I have issues with both of those continuances, but I don't want to belabor that point right now because I don't believe that it would make a difference as far as when we're looking at when the commission's jurisdiction would expire. So essentially what we're saying is that even if we take notice or even if we agree that both of these continuance requests were handled properly, that would only add 60 days, 30 days for each continuance. It would only add 60 days to the extension of the 1-year mandate by which time the commission needs to either render a decision or dismiss the complaint. That 60 days would bring us to December 21st at midnight, which was this past Sunday. So as of today, or actually as of the 22nd at 12:01 a.m. yesterday, the commission no longer has jurisdiction over this complaint and per statute is mandated to dismiss the complaint.
All right, thank you. Attorney Smith, do you wish to respond?
Yes, thank you, Mr. Chairman. I would first point out that I would disregard any references to facts in the motion to dismiss, to the extent that Respondent's Counsel claims that she has issues with the continuances under 9-7B43. The commission in no event may review new evidence, and therefore, had there been objections to the continuances, Those could have been made at the hearing on December 12th, had the respondent and counsel attended that hearing. In terms of a procedural matter, I would also suggest under 9-7B-43, they are very limited purpose of this meeting today. And the statute says that the no party would be able to raise any additional issues that were not raised at the hearing, and that the sole purpose of this is to address the facts and the conclusions within the proposed final decision itself. And so that dovetails with another point that I would make. This motion before you is not properly before you, to the extent that parties make a claim of the commission's lack of jurisdiction. They can do so on appeal, and that is not where we are today. Again, under 9-7B-43, this is a consideration of a proposed decision of a contested case. However, to address the issue raised by this motion to dismiss, which I received yesterday afternoon, I would point out that based on the facts and the record from that December 12th hearing, we have two continuances. Those two continuances are based on an October 22nd, 2024 filing of this case. Those two continuances added 60 days. Those 60 days would have landed this past Sunday on December 21st, landing on a Sunday that therefore would have had a resolve by date now on December 22nd. However, I would point out that on November 11th, state offices were closed for Veterans Day. I would also point out that on November 27th, state offices were closed on Thanksgiving. So we do have jurisdiction in that this case resolved by date is December 24th, 2025. But again, I would point out that I don't think this motion is currently before you in a correct way, and that this would be taken up on appeal should this matter be taken up on appeal.
So part of your
May I
argument,
respond?
Attorney Smith, I'll let you speak in just a moment, Attorney Rowe.
Thank you.
One of your arguments sounds like as long as a hearing was started before the end of the 1 year and a new clock runs for the decision to be made by the hearing officer, is that what you're arguing?
No, I'm not arguing that. What I'm arguing is that, and while the commission may take that approach, it's not an argument I'm making today. The argument that I'm making today is that on the facts, based on two 60-day continuances, that the October 22nd, 2024 filing of this complaint was extended. The original resolve date a year after that would be October 22nd, 2025. If you add 60 days to October 22nd, 2025, you are at December 21st as the resolve by date. That resolve by date, because it landed on a Sunday, then has us at December 22nd. Because state offices were closed for 2 days, you add 2 days to December 22nd. Therefore, the resolve by date is December 24th. And you have full jurisdiction to decide this adopt this hearing officer's report today.
Commissioner Pietzo.
So Attorney Smith, your position is that the second 30-day continuance was in fact a 33-day continuance?
That's not my position at all. No, it's not a 33-day continuance. If a continuance of a matter lands on a Sunday, or you have the opportunity in both cases, the November 11th closing of state offices on Veterans Day would have occurred in the context of the overall resolve by date. So that's an additional day. And then you would have the closed state offices on November 27th, Thanksgiving, which is an additional day. If you take the 60 days based on these two continuances, we reach December 21st. Because it lands on a Sunday, you have to go to Monday the 22nd. Because in the course of that year, with the additional 60 days, they're closed on December 23rd and 24th. When calculating those 30 days, you need to calculate them based on the fact that there were 2 days that the office was literally closed. And I do see that this statute is made to speed the state along, but it's not made to handicap the state.
All right.
May I
So,
respond?
yeah, hold on just 1 second. I have one more question, then I'll call on you. These extensions, were they expressed as being to a given date, or were they in each instance a 30-day continuance?
They were in each case a 30-day continuance.
I'm muted. I'm just, yeah, everything is going well.
Miriam.
It's snowing.
Miriam, you're on, your mic is open. All right, so Attorney Rowe.
Nice holiday. Hope you're having a good one.
Can somebody mute that, please? Thank you.
Attorney Rowe.
Well, let me first start out by reading the statutory language, and this is my interpretation. This is the language. For any complaint received on or after January 1st, 2018, which applies to this complaint, if the commission does not by 1 year following receipt of such complaint issue a decision thereon, the commission shall, which means must, dismiss such complaint, provided the length of time of any delay caused by the granting of an extension or continuance to a respondent prior to the issuance of such a decision. Period. It does not say, except for state holidays, it does not say that the state holidays don't count towards that 1 year. And I find it interesting that Attorney Smith is handpicking a couple of holidays that just happened recently to try to add to that 1 year time frame plus the 60 days for the two continuances when there was a myriad of holidays. But I guess he only wants to add the last two that have come up recently. There's Thanksgiving was last year. I mean, we can go on and on about this, but the statute does not say subject to any days when the state is closed. It doesn't say that we're only going to count work days. It doesn't say weekends don't count or holidays don't count. If the legislature had meant for those days not to count for that 1 year time period, they would have put it in the language here, but it is not in the language. So I find it interesting that that's being cherry picked here. I didn't want to get into the continuance request. First of all, it's the granting of the continuance, not the request for the continuance. That would add those 30 days on if it's a 30-day continuance. But when we look at, let's just pull the one continuance that Attorney Smith and I had agreed upon. What I received in return, and it is in your packet, is the, pull the paper here, where it says, and it's just a 1-sheet paper. The bottom is dated the 29th of October, 2025. It looks like Michael Agello, I'm sorry if I'm butchering your name, granted this. But if you look at this page here, the granting or denied isn't even circled. I can't tell if it's granted or denied. And it's not even for our case. The case is listed for the complaint by Kevin Coughlin, Brantford file. It's not even our case. So I can argue this in court all day long that this is not an effective continuance. But setting that aside for a moment, the 60 days I'm sorry, the 1 year plus the 60 days expired on December 21st at midnight. So to cherry pick a couple of days here and there when the state offices were closed does not comport or comply with the statute as the statute is written.
May I respond, Mr. Chairman? Mr. Chairman?
Mike, you're gonna have to stand in.
I guess we lost Steve.
May I respond?
You may respond.
Okay, couple of points. The inclusion of Veterans Day has nothing to do with the fact that it happens to be a state holiday. It has to do with the fact that one of the
Hold on.
continuances.
Hold on, Will.
Go ahead. Sorry.
I don't, maybe I was the only one knocked off, but I have not been able to hear anything for probably 5 or 10 minutes now.
So
Was I
would
the
you
only
like
one that
me
was
to
knocked off?
I'm sorry, sir. Would you like me to reiterate what I stated? I'm not sure. This is Carolyn Rowe. I'm not sure if you heard what I had stated.
No, you were speaking when am I the only one that got knocked off then?
Yes.
Steve.
Oh, sorry, I thought everybody was off. All right, well, I can't control that.
Okay, I can reiterate if you like.
Fine.
Okay, so what I initially did was I read through the statute and the specific language of the statute because Attorney Smith raised the issue of even though the 1 year and 60 day with the 2 continuances would put the deadline for adjudication to be December 21st at essentially midnight. Attorney Smith, and I'm not putting words in his mouth, but had stated, I didn't know if you heard this, but he had stated that there were holidays, Veterans Day, Thanksgiving, I believe is what he said, that would add to that time frame, which would bring the deadline. I'm going to say, I think it was December 23rd, which is today, and that the committee still had, or the commission still had jurisdiction over this claim as of today. My argument against that is, like I said, I did read through the statute here and the statutory language here. Let me get it for you. The statutory language states that, and this is, statutory language states, for any complaint received on or after January 1st, 2018, if the commission does not by 1 year following receipt of such complaint issue a decision thereon, the commission shall, which means must, dismiss such complaint, provided the length of time of any delay caused by, essentially by these continuances, any granted extension or continuance to a respondent prior to the issuance of such decision. So the language is clear. If it's not done by 1 year, it's dismissed, period. If there are continuances, which are exceptions to that 1 year, then that time frame for those 2 continuances is added onto that 1 year time frame, which brings us to December 21st. And I don't think Attorney Smith is arguing against that. He's saying there was additional days, I'm just going to paraphrase, he's saying there were additional days because there were some holidays involved. And my argument is there's a ton more holidays. So why are we just cherry picking these 2, this past Veterans Day and this past Thanksgiving Day, when the state offices were closed, and that the deadline of December 21st falls on a Sunday. So therefore that shouldn't count. If all of those days didn't count towards the 1 year deadline that the legislature put in place, they would have put that language into the statute. The only language in the statute says if it's not done, if it's not concluded by 1 year's time frame, subject to any of those continuances also, then that's it. The jurisdiction is done. It didn't say except for holidays or except for weekends or except for Sundays or except for when we're closed for snow or whatever it is. It said 1 year, period, end of story. The language is not in the statute. That's essentially what my response was.
Mr. Chairman, if I may.
Yes.
Mr. Chairman, it would be my recommendation at this time, obviously to continue to hear from the parties, but I think it may be useful for you to inquire from both parties as to whether General Statutes Section 9-2 is applicable to this situation, and if so, how it should be applied.
And why don't you or somebody describe what the thrust of that statute is.
So I will read that for the benefit of everyone on the call. General Statutes 9-2 is the calculation of period of time. In this title and the sections listed in section 9-1, when a period of time is prescribed for the doing of any act, Sundays, Saturdays, and holidays shall be included in computing such period, except that if the last day of such period is a Saturday, Sunday, or holiday, such day shall not be counted, and the last day shall be the day following such Sunday, Saturday, Sunday, or holiday.
Commissioner Wallace, sorry, you had your hand up.
Yes, yes. I just had a question for Attorney Rowe. I'm just curious if there was a reason or any documentation to support the fact that no one from your party or your side attended the hearing that was scheduled. I don't know if there was any communication provided around that.
Oh, I appreciate the question. I never saw the notice for that hearing. I never got anything in the mail. We're supposed to be getting written hard copy notices of everything, and we've received nothing. The only thing that I've received at this point in the mail recently was I got a notice in my mailbox yesterday that there was a letter I had to sign for, and I'm assuming that it is the transmittal of the proposed final decision. That I haven't even gotten hard copy yet. So I never got a hard copy notice. My client never got a hard copy notice. I never saw any notice of the December 12th. We didn't hear it. We didn't know about it until we were emailed this proposed final decision. But we haven't even received that hard copy yet.
And I would just follow up with a question for Attorney Smith. Do we have the certified mail receipt returned to us?
For what?
Sorry, the hearing.
For the original hearing? That to stand by the record, and this is not a process today to redo the hearing record. The hearing record shows that the notice of hearing went out. It is incorporated in the hearing record, and whether or not the receipt would have come in is something that either the clerk of the commission or the procedural advisor would have. And the other point I would make is that Attorney Rowe, as the record indicates, was informed in writing that these instances occurred by email. So there is an email in the record to Attorney Rowe explaining that the hearing would happen on December 12th. So let's just be perfectly clear about that. The other thing I genuinely need to respond to is that any insinuations about whether something was cherry-picked or not are completely an aside. The only reason these two holidays were included in the calculation of resolve by date is because they happened to happen in the course of this time, after continuances were granted. In terms of the legal, or excuse me, in terms of the factual arguments, there is no opportunity for Attorney Rowe to make factual arguments against the record. She claims that she could argue all day in court that this wasn't done correctly in the continuances. My position would be, let her do so. If she wanted to make these arguments, she could have shown up at the hearing with her client. In terms of responding to 9-2, no, 9-2 doesn't apply. 9-2 is framing procedural requirements of this commission. It also frames procedural requirements for both election days, referenda, campaign finance filings. Sure, all of that is in 9-2, but it does not reference or indicate how we are to implement the resolve by date. The procedural part that 9-2 would govern is this final decision. So within a year, this final decision must be made. That is what the procedural ramifications of 9-2 are. Yes, absolutely. Within a year, 9-2 would require a decision to be made with or without state holidays or Sundays or Saturdays. I don't exclude 9-2 from a point. My point is that you are satisfying 9-2 because based on 2 60-day continuances, one of them landing on this past Sunday, two of them being obviated by 2 state holidays, the resolve by date is December 24th. We're not using 9-2 to decide a procedural thing here. There is no description of how we implement resolve by dates. The procedural 9-2 is resolving this. I would also point out, this is not a calendar year. It says within a year. It doesn't say within a calendar year. And then it invites the commission to appreciate either extensions requested or extensions because of subpoenas contests. So don't obscure the resolve by date, which is something that we have to put in internally based on the statute which provides for these extensions.
Commissioner Pietzo.
So the complaint was received October, and this is to Attorney Smith, October 22nd, 2024, right?
Correct.
There's no dispute of that, right? That's a stipulated fact. That's a matter of public record. Correct?
Correct. It's in
Okay.
our record of hearing.
Okay. All right. So that we don't need to have factual findings. We don't have to reopen evidence on that. Okay. That's an issue that we can take notice of. So, I mean, wouldn't you agree that the 1 year rule in 9-7B basically is a jurisdiction stripping statute?
Yes, absolutely.
I mean, and to us, the 5 of us, the commissioners, it says if the commission does not by 1 year following receipt of such complaint issue a decision thereon, the commission shall dismiss such complaint. I'm not saying that I like that language, but that's the language, isn't it? So, I mean, wouldn't you agree that much like a court, we as administrative agency must assure ourselves of jurisdiction?
I absolutely agree with that, but you need to read the entire statute, which says unless there are extensions based on a subpoena or based on requests of the parties.
Right.
That
okay.
occurred
And that's where I'm going next. And that's where I'm going next.
Okay.
So we're past the 1 year. So
Yep.
in order to assure ourselves of continuing jurisdiction past the year, we need to, now that this issue has been raised, find that there has been a continuance basically agreed to by the parties. And what I'm hearing you say, Attorney Smith, is that there were 2 30-day continuances agreed. That's the position of the state. That's right?
That's correct.
Okay. And if I take 60 and I add that on to October 22nd of 2025, I come to December 21st. Is that right?
That's correct.
Okay. Which was and that was a Sunday, right?
Correct.
So the following business day was yesterday. Is that right?
Correct.
Okay. Thank you.
Mr. Chairman, if I may.
Yes.
I believe it may be useful just for me, and perhaps I'm the only one that's having some difficulty following, of walking through with the parties their specific arguments on the chain of events. Would that be acceptable?
Yeah, I need to identify who you are for the record.
Oh, again, for the record, Ryan Burns, Executive
Attorney
Counsel and
Ryan Burns, yes.
Executive Director and General Counsel.
Right. And so what is it you propose to do?
I would just like to go with each party through their arguments on timing to make sure that it is clear what the arguments being made with regard to any extensions that have been argued.
Certainly.
Okay. I would like to start with Attorney Rowe, if I may.
Yes, sir.
So to be clear, you have the complaint file date is not in dispute, correct?
Correct. October 22nd, 2024.
Okay. And you believe there's an argument whether extensions were made. We're going to put whether or not those extensions were valid to the side for a moment, if we could. What was the date of the first extension?
Let's see. I know that's in part of the packet, but I will find that for you. It was an email that came from Mr. Jenkins.
Okay. And I think we can dispose of, I guess it's less important when it was filed, but when do you believe that extended the date to?
It would be 30 days. Well, it would be 30 days added onto the 1-year time frame. If we look at the language of the statute, it's not a matter of when it was filed and when that 30 days would end. It's a matter of continuances that are granted add to the 1-year time frame. So in other words, if the commission is supposed to dispose of this claim within 1 year, it makes sense then if a 30-day continuance was given, then that would be 1 year and 30 days. So it does, you know what I'm saying? So it's not necessarily going as to when it was granted or not. It just
Correct.
essentially adds that 30 days to the end.
So your argument is what date was the resolve by date after that extension was granted?
After the first one, well, let me pull up my calendar. 2, 3. 17. It looks like November 15th, if I'm adding correctly.
So adding 30 days to a resolve by date of October 22nd gets you to November 15th?
Yes, in fact, I'm recounting just to make sure, because I might be off a little bit. In my head, I just had the 260 day, the 230 day, and I counted 60 days out. So I didn't break it down to 30 and 30. 1, 2, 3, 4, 5, 6, 7, 8, 10, 17. I'm sorry, I was wrong. That November 21st, it looks like.
Okay. And what day of the week was that?
That was Friday.
Okay. Is it your position that there was any state holiday on that date?
I'm just looking at a general calendar. I don't have a state holiday calendar here. So I just have a general calendar that I'm pulling up on my computer, but it doesn't show state holidays.
Okay.
Let me see if I can get that answer for you. 2020. On that particular day, let me go back. That was November 14th. I just did a quick Google search on Connecticut state holidays.
I don't think it's November 14th. I thought it was November 21st.
I'm sorry, November 21st. Thank you for that. I don't see any state holidays on the 21st. And just a quick Google search.
Okay. So you believe, and then there was another 30-day extension?
Yes, there was. Well, I think there's some issues with it, but let's put, like you said, let's put that issue aside for a moment. And yes, there was another 30 days.
And what date is your position that 30-day extension ran?
15, I'm just recounting. 16, 17. Would be, that ends December 21st, which is a Sunday, to anticipate your next question, potentially. But that would be December 21st, which is a Sunday at midnight. If, as you pointed out, we are to take into consideration, I believe it was 9-7, I think section 2 you said, then it would move to the 22nd, which would be yesterday.
Okay, so your position is that we do apply the addition of Saturdays and Sundays to that calculation, and then as a result, the time period ran on Monday, yesterday.
Well, I don't necessarily agree that section applies, but even if it does, it only brings us to it brings us to yesterday's date.
Do you have a position as to why the calculation of period of time in section 9-2 would not apply to this examination?
Only that it was just brought to my attention now. I don't think in just a quick cursory read, I mean, it's a pretty simple read of that statute here. When a time period is prescribed for the doing of an act, Saturdays and Sundays shall be included in computing such a time period, except that if the last day of such period is a Saturday or Sunday, such day shall not be counted, and the last day shall be the day following that Saturday. I still think it supports our argument, but if you take this into consideration, then yes, the 22nd. Without doing any more research on any case law or anything, I'm just looking at the cursory language of the statute here. I don't have any problem with the
Well,
statute.
it's your motion, so we need to know what your position would be with regard to how to calculate this date.
Well, without being able to do any research with regards to case law, if there was any case law with regards to this statute here, I don't have any argument with 9-2 as it's written here.
Okay, so it's your position that the time period ran yesterday.
If we're going to include 9-2, yes.
Commissioner Piazza, before I turn to Attorney Smith, you had something?
Is there any question that the issuing of a decision is an act, as that term is used in 9-2? Wouldn't that seem to make sense?
Is that a question to me, Commissioner, or to
To counsel? To counsel.
Oh, I'm sorry, I didn't hear that. Could you repeat that, please?
So 9-2 talks about the doing of any act that would include the issuing of a decision, would it not?
I would say yes, but I'm kind of couching that with the fact that I don't have any additional information to go on except the language of this statute here. I don't know if it's been adjudicated in any other cases where any definitions of any of these words were further addressed. So
That's fine. Thank you. That's fine. Thank you.
Thank you.
Attorney Burke.
Attorney Smith, I want to go through that same kind of process with you. You agree that the complaint was filed on October 22nd, 2024?
I do.
And there was a 30-day extension that was granted?
I do.
Okay, so when that first 30-day extension was granted, what do you argue was the resolve by date?
You would put the October 22, 2025, you would do plus 30. The extension was granted on I believe the 20, is it the 29th? I haven't, just looking at my record.
Is the data granted relevant to this discussion?
Oh, right. So, okay. I'm sorry. Thank you. No. So you would take the October 22nd time out date and you would add 30 days to October 22nd. Yes, I agree with that.
Which brings you to what date?
I would point out that it would bring us to, because Veterans Day landed on November 11th, it would put us at November 22nd.
Okay, can you, looking at the application of 9-2, would you concede that that applies?
No, there are two distinct issues here. One is jurisdictional and one is the timing of an act. I would concede that your issuance of a final decision is an act and it is governed by this, correct?
Okay. So you said, what was the date of Veterans Day?
The 11th.
So how is it when the statute says, when the period of time prescribed for doing any act, Saturdays, Sundays, and holidays shall be included in computing such period? So are you arguing that that date should not be included for some reason?
Right, because that calculation of the time period is with regard to, say, the issuance of a notice or the issuance of a hearing notice or what have you. But we're not calculating it for purposes of the year that we had to get this done. That is a calculation to create what your jurisdiction is. So in calculating the jurisdiction, I don't believe 9-2 applies. No.
Okay. So under your argument, we should not count, should we count the Saturdays and Sundays then either?
I didn't count them, and I wouldn't count them because historically when we update a resolve by date, we don't we use Saturdays and Sundays. Yes, we use them. But when a state office is closed, that's a very specific thing where the state doesn't conduct its business on that day.
Okay. So it's your position that we should not include state holidays in the period of time during that extension. And therefore, the new resolve by date after that first 30-day extension was what?
It would be November 22nd.
And that was, just for the benefit of everyone on this call, November 22nd was what day of the week?
It would have been a Saturday, which would have pushed us to the 30 days would have therefore been, would have to have been on a Monday because the resolve by date would have landed on the weekend and the end of the case would have landed on a weekend. Therefore, you would have put it on November 24th. So
Okay.
November 24th would have been the new resolve by date.
And then your position was another 30-day extension was granted?
Correct.
And that brought, what is your argument that with the 30-day extension brought you to what resolve by date?
Well, with the resolve by date of November 24th, you would then I'm sorry, just a moment. It would have been December 24th, 2025.
Are you extending it for Veterans Day and Thanksgiving?
The first one, yes. If you extended it for Thanksgiving, it would then be Christmas Day. So you would have till December 26th to make a final decision on this. And that act would be within that year. Yes.
So your position is that the resolve by date is December 26th, 2025.
Yes, yes, I do see why that would be the case. Yes. I had plainly argued that it was December 24th, but based on one of the 30-day extensions landing on a Saturday, yes, I see your point. Yep.
Okay. Mr. Chairman, unless you would like me to inquire further, I believe I.
Well, yeah,
turn this back over to you.
I personally need some clarification at this point and see whether the parties can agree or not. 1 year is whatever that year is. Some years have an extra day in them, as I recall, now and again, right? So it's
I'm
1 year.
listening.
Can we agree on when was the date that the 1 year expired? What is the state?
If the complaint is filed, this is Caroline Rowe, if the complaint is filed October 22nd, 2024, if you wanted to count out 365 days, I believe it would expire October 21st at midnight.
October 21st, okay.
At midnight.
And what did we decide in this discussion? Was October 21st a weekend day or a holiday?
No, the 21st is a Tuesday and the 22nd, again, of October is a Wednesday.
So we add 30 days more, starting with October, start counting October 22nd and count 30 days. Is that correct?
Yes.
And what date does that bring you to?
Okay.
It brings us to November 20th, which is a Thursday and not a holiday.
Okay. And then
Wait a minute.
Go ahead.
Excuse me, Mr. Chairman. October 22nd, 30 days after October 22nd. I'm sorry, 30 days after. This is regarding the first continuance, correct?
Yes.
Right. So 30 days after.
So the first day is October 22nd, day number 1.
Yep.
30.
Yes. So it lands on Friday, 21st, 2025. And I've obviously at Friday, October 21st, 2025. And I've made my position clear. You have to add Veterans Day, November 11th, which lands it on a Saturday.
Okay, actually, no, I'm going to disagree with that. If we stop talking about continuances for a minute and just look at the 1 year, if it's filed on October 22nd, 2024, your jurisdiction doesn't expire then on October 22nd, 2025. It expires midnight on the 21st. That's day 365, the 1 year mark. The first day then, where the continuances begin, where we start to add the 30 days, would be November 20th. November 20th would be day 1 of the first 30-day continuance. Because October 20, I'm sorry, sir, go ahead.
If you do not count the day of filing, which is what our courts typically do not do, you do not count the day of filing, and you then did 365 days or 366 in a leap year, that would bring you to the same calendar day of the following year, right? So if we do not count the day of filing, you'd agree we'd be at October 22nd, 2025, correct?
Yes, if we're looking at that, then the first continuance goes to November 21st, which is a Friday, which is what's written in the motion here.
So give that to me again. I'm sorry, this is getting confusing.
In other words, if we were just looking calendar year, then the October 21st would be the expiration date. But as Mr. I'm never going to get this name right, Peace,
Yes,
as,
so.
thank you, stated and pointed out, generally courts, and we're not in a court right now, but generally courts will not look at the first day the paperwork is filed and count that as a full day. So essentially, the expiration, if it's filed on October 22nd, 2024, the expiration of 1 year would be October 22nd, 2025. If we then add 30 days, the first 30-day continuance, that brings us to November 21st, which is a Friday, not a holiday.
And then the second 30 days, where does that land?
That lands us-
Mr.
I'm sorry.
Chairman,
Sorry.
I think you're asking me these questions.
I am.
And
Asking anybody to
and
answer them at this point.
well,
Go ahead. Attorney Smith.
following this path, I would point out 2024 was a leap year. And I would also point out the statute says a year. It doesn't say a calendar year. Doesn't mean it's 365. If you wanted to use 366 for a leap year, then you would add a day. But your question is, assuming that this first continuance went 30 days, you would add 30 days to October 2020. You would add 30 days to October 22nd, 2025, and you would land on November 21st. As I've argued, I think you need to add a day because of Veterans Day.
Steve?
Yeah.
Can I just try to be helpful here? I think if I put it side by side for you, I think Attorney Rowe is saying the first continuance goes to 11/21/25. Attorney Smith is arguing it goes to 11/24/25. He's counting Veterans Day and Saturday and Sunday. So he's adding the 3 days because of where it lands. Then the next continuance, Attorney Rowe, I believe she stated when talking to Attorney Burns, it was 12/21/24 would be 12/21/24, which would be a Sunday. And if 9-2 counts, it'd be 12/22. Attorney Smith said he would count that next 30 days would be 12/26 would be the resolved by date. And that would include 2 additional days, which were Thanksgiving and Christmas. So that's where the two parties diverge is Attorney Smith is incorporating in Veterans Day and the fact that it falls on a Saturday. So he's adding an additional 3 days for that first continuance and an additional 2 days for the second because there are 2 holidays. Attorney Rowe does not add those days. Do I have that? Does that help? And do I have that correct?
Yeah, I think it helps.
I think
Well done, Shannon.
Yeah.
And I would agree with you too, if that matters. I would agree with what you said. And the reason for the divergence is because I'm actually reading the language of the statute and not adding my own language to it.
But that's where that's where the parties disagree. And I think that's where, the commission needs to decide where we land.
Okay. Anyone else need to be heard? Yes, Commissioner Pietzo.
I'm prepared to make a motion, but I would ask if appropriate through you, Mr. Chairman, whether or not we want to ask the Executive Director and General Counsel if he has a viewpoint on this matter.
I'm happy to receive the Executive Director's input.
Yeah. In this instance, I do not believe that the commission can ignore the plain language of 9-2, which does not, unfortunately, allow us to add state holidays that happen in the interim unless the last date falls on a Saturday or holiday. So even if Attorney Smith's calculations were put forward and the 1 year originally ended on October 22nd, this would not allow the commission to reach a resolve by date that would grant the commission jurisdiction over this matter today.
Okay. Commissioner Pietzo.
With that, and with regret, I would move to grant the respondent's motion to dismiss.
Is there a second?
Second, Berkeley.
Is there discussion? None appearing? Those in favor of the motion will raise their hands and or say aye.
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 Any opposed? Any abstentions? None appearing, the motion is granted. And
Thank
the case is dismissed.
Thank you.
Right. Anything else to come before the commission today? What am I missing here?
Yes, Mr. Chairman,
Price
there is still a
index?
discussion of the consumer price index, correct?
Okay.
May I be excused? I'm sorry. I just want to make sure that you don't need
You
me for
may.
anything else. This is Attorney Rowe. All right. Thank you very much. I appreciate it. Have a wonderful
Thank you for
holiday,
attending.
everyone.
Yep. Consumer price index. Who do we call on for that?
I'll take that as well, Mr. Chairman. Though I may invite both Attorney Keefe and our accounts manager, Salman Munir, as no one wants to hear from a lawyer on math. But generally what we have before you today is before the new grant cycle, we're required to, by statute, adjust various numbers, including the qualifying contribution amount and the grant amounts based upon the consumer price index. That there is a fixed date by which those need to happen. That's both in December and January. That date was pushed back several days due to the government shutdown and the late release of numbers for the General Assembly. Because there is a date by which we have to release it, and because it is a non-discretionary act of the commission, and it is a mathematical calculation, rather than something that the commission may adjust at their discretion. That number was released immediately upon the federal government providing that information publicly. But we wanted to put this on the agenda to ensure that the commission is, again, granted due deference in their execution of their duties. I have heard from at least one commissioner that there may be interest in taking a vote to ratify this action. I don't believe such a vote is necessary and may create complications, but that being said, if the commission feels compelled to vote on this, they are free to do so. I would encourage you to vote in support, as failing to approve this would put us in statutory violation and create some uncertainty in the environment. But again, with that, I will turn it to the commission.
Right. So when does this decision need to be made?
It is my position no decision needs to be made today, but the commission is free to make a decision if they so choose. There has already been publicity of this number change, as there are people currently raising money with regard to the 2026 CEP cycle, and they needed to know what that number would be, and we were required by statute to issue that number by the 15th, but that number wasn't released on the 15th, so released it as soon thereafter as was feasible.
So this could go over to the next meeting then?
If you want to have further discussion on this at the next meeting, you certainly could.
My only concern, and I don't know, I may be about to misstate the realities, but there were a lot of missing statistics that occurred in November. I think they had more to do with jobs, numbers of jobs created than the consumer price index, but I don't know for sure. But I think the federal government is waiting for better information on similar matters.
So, and I see I see Shannon has joined us as well. My understanding, and Shannon, if I state anything incorrectly, please let me know. There was October CPI adjustments that were not released by the federal government in November, but the November data was released in December. It was just 3 days late. And that is the number upon which, by statute, we are required to rely on.
Right. And so we have an obligation, I take it, to be heard on this matter, to take a vote. But we don't have any. You didn't give us anything. There's no background. We don't know the numbers.
So it is not my position that you are required to take a vote on this, but there has been expressed to me some interest that the commission may want to take a vote. That is obviously within your authority if you choose to do so. Though again, I would encourage you to support the adjustment that was made, as it is statutorily required, and failing to do so would introduce significant confusion within the regulated community.
Well, that suggests that we have a legal obligation to take some action today. Yes, Greg?
So my only observation is that Title IX is rife with the words "commission shall." I pulled up this public act, which is referenced, which is has 26 just in that public act 2526 alone of commission shall. I'm not entirely clear in terms of in what instances commission shall means the five of us shall, or in what instances commission shall means the agency or staff or the executive director shall. I'm just flagging that issue. There are certain things, from my viewpoint, the commission shall has to be the five commissioners. For example, disposing of an enforcement case, promulgating regulations that could go on. There are other things where probably it doesn't mean the five of us need to act. I just want to raise the issue of I'm not entirely clear as to what's been delegated or not. If there's any list of all of the statutory requirements that the commission shall do or do not, and if we sorted out what needs to go to the commission or not. That's perhaps a project of greater scope than just today's meeting. But I am the one, I'll raise my hand, and I did indicate to the executive director that I don't know where the line is, but I'm not comfortable based upon the former executive director that we're getting all the information all the time. And I just want to make sure that we are in the loop on all this stuff. If it's the consensus of the five of us, this is fine. I don't feel like we need to take a vote, but I don't like the idea of stuff happening without us knowing about it. That's the long and short of it.
Okay, well, Shannon Keefe, I'll draw on your knowledge. You've been around here longer than most anybody.
Thank you,
How is
Commissioner.
how has this
Um,
decision been made before?
This is a pure mathematical calculation that our Director of Audit does on spreadsheets. One of the pieces of feedback we've gotten is that they want this to be released immediately upon receipt of the numbers, and that has been very strong feedback from the legislature. I don't think that the commission needs to vote on this because it's statutorily required and very well spelled out how we do it, including that we're to round up to the 10th or the 100th, and what we do if it's an even five. I mean, it's very clearly statutorily spelled out. The numbers made available by a federal agency, we pick that number up, we put it in the spreadsheet. If the commission chooses to vote on it, I would suggest you plan a special meeting and to be ready to adjust the special meeting to the day that they do end up releasing the number, so that we can do what the legislature has repeatedly asked us, and get the number out immediately. People are relying on it for their fundraising and their strategic planning.
And Mr. Chairman, if I may.
Yes.
To address Commissioner Pietsu's larger point about ensuring that the commission is given their due deference, I will begin the endeavor of trying to tease out what authorities have been granted, and perhaps having more formal delegations may be a useful tool for the commission to make sure that everyone's on the same page. In the interim, my proposal would be for discretionary acts of the commission, those should of course be brought to the commission, and no decision should be made before the commission has weighed in and actually issued their decision. But for non-discretionary acts, I would encourage the commission to empower their staff to execute those non-discretionary acts with due notification to the commission, and of course to bring the commission in should there be any confusion or judgment calls that need to be made. But again, I defer to the commission's judgment on how to proceed.
Well, I don't see what we add to the process. I can't imagine there's any of the five of us that have any background with the consumer price index. So I'm quite happy to rely on what the staff has done. Oh, I'm sorry. Okay. So Commissioner Worrell Asari has agreed to set the commercial.
I'm not going to say it, but I think we have to adopt it. But I do have a background in it as an economist.
So what do you think we should do, since you have a background?
Well,
mean,
I don't think that we have a say in the matter other than to just acknowledge that it's been set. It's not something that we, of course, would be calculating. It's done by the federal government. So, it sounds like we have to release it in order for those who are relying on it to have that information available, even though it's federally available. I think we're just doing an acknowledgement of it. If we have not historically voted on, to me, to vote on something means that you are either rejecting it or accepting it. And that's not something that we have any power or control over, to accept or reject. If you want to use it as an acknowledgement, maybe just adding to the minutes that the commissioners acknowledge that we have formally released the CPI, that's fine. But I don't think that's something we can vote on, because we can't vote it down or vote it up. It's federally set. So that's just my opinion on it.
Is it a single number, or does the context make a difference?
So go ahead. Go ahead.
I guess it depends what you're asking. The CPI adjustment is based upon a single number that's issued by the federal government in our context.
Okay.
It's applied to several different numbers that we use to issue grants, including qualifying contributions and grant amounts. But again, we are making a mathematical calculation based upon fixed numbers that exist in statute.
Yeah, Greg.
Just to be clear, going forward, I do not want to be involved in having to vote on this stuff. I think that this is a very easy case. These are things that obviously the staff has expertise in and should be able to do. The point that I'm just wanting to raise through this is that there are cases that are closer calls. We had our regulations amended because there was a statute requiring us to amend our regulations, and that process happened. And the commission wasn't aware of it and didn't see the text until after it was promulgated. I think that lies on the other side of the line. I'm just using this as an example of maybe in the next 6 months, we can just get our hands around what all these commissions shall, so that we all have a good understanding of, okay, what are we comfortable with staff just doing and what are we not comfortable with? So for me, amending regulations is a hard no. Staff does not amend the regulations without commission voting on it. We don't, generally settle enforcement cases that we've delegated some non-filer stuff. But I don't need to have a vote today. It's just, it was important to me that I just raised that issue. Thank you, and I'm going to stop talking.
All right. So I think I'm understanding that we're quite comfortable with the staff, the agency itself, making the determination and implementing it. And if I don't see any objection to that, then why don't we consider that that's what we've just done? You don't need a formal vote, I take it? Mr. Executive Director? No
Yeah,
formal
if
vote?
you're declining to take a vote, then no formal vote is needed.
That's fine. Thank you. All right. Is there anything else to come before the commission at this time? Then occurring, is there a motion to adjourn with the understanding that we wish a happy holiday to all?
That understanding, I move to adjourn.
Second, Berquist.
Moved and seconded. Those in favor of the motion to adjourn will raise their hands and or say aye.
Aye.
Aye.